Are we on now on?
We are now on.
You're on now, yeah.
Apologies.
Thanks, Kevin.
Thank you. Apologies all. A slight technical glitch that's seen us talking to absolutely no one for the past few minutes. So my sincere apologies for keeping you all waiting in the queue like that. So I think we'll move swiftly on and we'll learn from that one. But thank you for your patience. Yeah, what did you miss? Well, you missed me saying good afternoon and thank you for joining us. I might as well say that again, first things first. Thank you for being here with us today. My name's Owen Black from the Distribution Commercial Policy team here at SP Energy Networks. And I'm really very pleased that you could take the time to join us today. So thank you for doing so. It's great to see so many of you here, given that clearly this topic of queue management milestones or customer progression milestones, as we more typically refer to them, has real practical impacts for your projects connecting to the distribution network. And is doing so, of course, at what's a time of significant change in the industry, which I know all of you will be feeling in different ways. So thank you for taking the time to be here. Please do note this call is being recorded and transcribed. Now, we'll cover a lot of ground in this meeting here, but fundamentally, my aim is really quite simple. What I want to do is I want to give you clarity and confidence around how connection offers from SP Distribution and SP ManWeb will work following the implementation of the updated ENA queue management user guide, due to take effect on the 1st of October. I'd also note that one of the main aims of this project, or the working group, was to create greater consistency across all DNO's application of queue management milestones. So if you are joining us from another network area today, you're most welcome here, and I hope that you find this session to be useful. I do want to note, though, and feel important to note to anyone attending, what we're talking about today, though, I wouldn't treat as a substitute for reading and understanding the ENA guidance going forward, okay? Or, for that matter, reading through the customer progression milestones that you'll find in your connection offers going forward, which form your contractual agreement with us. However, we will try within this next hour to provide helpful context so that you're aware of what is changing and what it means for you. And we'll try to do that by running through why the guidance has changed and what this means in practice, what the benefits for you are as applicants and project developers from the updated guidance, what's actually changing in real terms, who the amended guidance applies to, the 3 project categories that now exist, which is to say TEA gated, TEA non-gated, and no TEA required, which we'll explain throughout. Exactly how we will calculate milestone dates going forward through forward-looking or backward-looking milestones. How the new 60-day remedy notice period works and how treatment of it may vary for the so-called early versus later milestones. And we'll chat you through each milestone one by one as well. And we'll outline the timescales for completion for each and the evidence requirements for each under the updated guidance. So there's a lot of ground that we'll go over here today. And you may note that the chat function has been switched off, purely because we've got a lot to get through and not so long to do so, in all honesty. I do, however, wish to be clear that we are open to contact by email, and we will try to ensure that questions are answered offline. So please do feel free to keep lines of communication open, which will be a bit of an emerging theme you'll hear today. And if you have any questions following today's webinar, please submit to stakeholderengagements@spenergynetworks.co.uk. But first up, apologies for the false start, Jamie. Jamie McDougall is going to set the scene and explain the why before we get to the what.
Thank you, Owen. Yep. Hi, everyone. Thanks very much for attending. As Owen says, my name's Jamie and I work alongside Owen and SPEN's Distribution Commercial and Policy team. So the first slide here we've got Why has the guidance changed and what are the benefits? So along the top, the guidance changed because we've, as we all know, have oversubscribed queues. And so the guidance, I guess, is effectively more important than ever in tackling projects that are stalled and in helping us to manage those. Secondly, for policy alignment purposes, so Clean Power 2030 and the introduction of connections reform, the guidance has had to be updated to make sure it basically stays in step with the gated processes and remains applicable. And then finally, to provide greater clarity and consistency. So as Owen mentioned, with regards to the other networks, there's been a move to align things a little more closely with the NESO's transmission queue management process. Now the benefits that brings is along the bottom in the circles, we've got more predictable evidence requirements and timelines. As I noted there, we've got greater alignment with the transmission queue management processes, and we've got fairer, more efficient queues. And I think that point on fairness relates probably specifically owing to forward and backward looking milestones and them effectively being, them being now catered for the projects that have very long lead times, and the milestones been more applicable there. Okay, next slide, please.
Yeah, and relates, of course, Jamie, to projects that are receiving very long lead times for connection because they're stuck behind stalled projects that aren't progressing in line with their contractual obligations. So yeah, fully agree.
That's good. Okay, so what's new? We'll take each of these in turn. So the remedy notice period's new. You would probably have been familiar with the process that was there before, which was a tolerance process. That has now been replaced with a remedy notice period, and at each milestone there'll be 60 calendar days beyond your milestone deadline date, and within which you have to remedy any delay. You then have, as I say, the introduction of forward and backward facing milestones. So if your connection date is less than 5 years in the future relative to your offer acceptance date, the milestones are calculated from your offer acceptance date, i.e. forward looking. And if your connection date is more than 5 years in the future relative to your offer acceptance date, then the milestone dates are calculated backwards from your connection date. And that, as we say there, accounts for the projects that have very long lead times. And in the old guidance, it would have been unreasonable to kick off the early stages with initiating planning permission and securing that the projects had such long timescales. Milestone 4 has been updated. That was always one that was there, but it has been updated to account for the gated process, which is obviously introduced as part of reform. I think probably you'll touch later on the timelines with regards to milestone 4, Owen. On milestone 2, that has been updated, and it's now set at 12 months in all scenarios, and that's 12 months from the date that you achieve milestone 1, initiating your planning permission. Milestone 7 has been updated to provide greater clarity in respect to stage payments, and there's been a breakdown provided on the scenario where the DNO is completing the contestable element of the works and where the DNO is not doing that. So we'll touch on that later, but there's been additional sort of detail added to the guidance around milestone 7. And then there's also been further detail and clearer treatment on the non-firm and phased connection offers that you may receive. So the milestones and the in the example given there, if your connection's non-firm, the milestones will be based on your non-firm connection date. Okay. Now, which projects does the updated guidance apply to? So I appreciate this is quite a dense slide. I believe we will circulate the slides after the session, Owen, so you will have this. But okay, so with regards to prospective applications, so how do they apply to offers issued on or after the 1st of October 2025? So for generation projects, regardless of whether a TEA is required, so transmission entry assessment, regardless of whether you need one of them or not, the updated guidance will apply Across all DNOs, it will apply to distributed generation connections at 1 megawatt or above, and then in Scotland at 200 kilowatts or above on the mainland, and 50 kilowatts or above on the Scottish Islands. And what we are just flagging there is that it's at the DNO's discretion to apply the milestones below those thresholds. And you will know if they're applicable because they will be in your connection offer. With regards to demand, again, regardless of whether you need a transmission assessment or not, if your offer has been issued after the 1st of October, DNOs will include the updated milestone guidance for demand connections at 5 MVA or more. And again, at the DNO's discretion, they may be applied to distributed demand connections below that threshold. Then moving to the retrospective application, so for offers issued prior to the 1st of October 2025, where you have a distributed generation connection that requires a TEA, then again, if your offer has been issued prior to the 1st of October 2025 and requires that transmission entry assessment, the updated guidance will apply again at the same threshold, so to projects at 1 megawatt or above, and then 200 kilowatts or above in Scotland and 50 kilowatts on the Scottish Islands. And again, that caveat just to say that, you know, the DNOs may apply them below those thresholds at their discretion. If your offer was issued prior to the 1st of October 25 and it's a generation offer and you do not require a transmission assessment, then you will remain on the previous version of the guidance. If your project is progressing through gate 2 to whole queue, all of the distributed generation projects progressing via that process will receive the updated guidance. And then finally, if your project is a demand project that was issued, where your connection offer was issued prior to the 1st of October, you will remain on the previous guidance. So that's me covered that slide. And as I say, there's quite a lot on that, isn't it? So I think it will definitely be useful to circulate these slides afterwards. Thank you.
Yeah, agreed. And thank you, Jamie. So I want to repeat something I said at the ENA webinar on this topic back in May, if any of you also attended that while the guidance has been refreshed, it hasn't been reimagined. That while there are updates, what you should find is a broad basis and familiarity with what you're used to. So milestones 1 to 8 remain broadly as you know them. There are no new milestones. And importantly, critically in fact, proportionality and fairness remain core principles. And I want to be clear on that. We understand that delays happen and that they don't necessarily indicate a project is not serious about progression. So where delays occur that are genuinely and demonstrably out of your reasonable control, we can still vary dates. Our job at SP Energy Networks is to ensure that all decisions that are taken in respect of milestones are fair, consistent, and transparent. In that respect, nothing has changed. And if I can offer one overarching message today, it's that we encourage open communication in respect of milestones. Now, one of the impacts, I should say, of the gated application and offer process introduced through connection reform is that it means we now have to consider how different journeys apply depending on the level of NESO interface that's required. Not dissimilar to the nuance and requirements where that happens now, if you have to go through a transmission impact assessment or not. But on that basis, we now have 3 core journeys, which I've tended to think of as 3 routes to connection that determine how milestone 4 interacts with the rest. But those journeys will broadly be referred to as the no TEA required journey, as exists today, the TEA gated journey, which is to say the journey that goes through gate 1 and gate 2 with NESO, and the TEA non-gated journey, which is broadly familiar with the MODAT process you would have known prior to TMO4+. When you receive your connection offers, you'll see evidence and timescales demonstrated for each of the 3 journeys. So please be aware of which applies to your project. We will identify and clarify with you if a TEA is required during the application and offer process. TEA, by the way, I feel I should note, because I know you've heard this acronym now from both Jamie and I, and I feel it has some potential to create confusion. So I want to be clear that the TEA here refers to Transmission Entry Assessment. And the reason I emphasize this is because that's not a term that you'll find in the CUSC or otherwise defined by NISO, but it's instead used within the ENA guidance to mean any scenario where an evaluation of transmission impact is required with NISO, be that through a transmission evaluation application or a transmission impact assessment. So in the simplest possible terms, TEA in this context simply means some form of NISO interface required. So the first journey I mentioned is no TEA required, right? And I would note that the 3 journeys are mapped out in process flow diagrams within the ENA guidance document, which I encourage you again to refer to and consider. But the no TEA journey means there's no NISO interface required or no NISO assessment required, and therefore milestone 4 or NISO interface does not apply. In this journey, your progress is generally measured in reference to your offer acceptance date or your target connection date on a backward-looking basis if your offer date is greater than 5 years out, which I'll come to next. The TEA gated journey, gated here meaning offers required to go through the gated application and offer process to determine impact to the transmission network. And we're mainly referring here to generation and storage projects that require or trigger NISO gating. But in this journey, you're required to go through NISO's gated process, meaning you must meet Gate 2 conditions within a fixed time frame of 24 months from your offer acceptance date. Now, I will chat through, as I said, each milestone in turn, but milestone 4 in this journey is the point at which you agree in writing to the NISO Gate 2 outcomes and conditions. And in this route, you may find this good news, land readiness is embedded in the Gate 2 criteria. So milestone 3, or land rights, is effectively satisfied through the gated evidence, meaning you don't have to duplicate it or evidence it to us separately. If you have received a successful Gate 2 offer, in our view, that means you have met the requirements of milestone 3, your land rights. And then lastly is the TEA non-gated journey. And what we're typically referring to here is larger demand projects that still go through NISO assessment, but which go through the MODAP process rather than the gated process. So milestone 4 in this scenario is the point you accept the non-gated NISO outcomes and conditions. And unlike the last one, the TEA gated journey, milestone 3 in this journey is still evidenced separately. So that's required within 2 months of completing milestone 4 on this route. Now, as Jamie referred to, one thing that was clear from customer feedback was that the status quo whereby milestone deadlines are calculated exclusively on a forward-looking basis isn't really working as intended. So particularly where, as Jamie said, connection dates are so far in the future that it makes no sense to start certain processes until closer to the time. That was the intent of this sort of change to having both forward-looking and backward-looking milestones. So we decided, or the working group decided, on a more proportionate approach whereby dates will be determined either on a forward or on a backward-looking basis. The group didn't fully align this to the almost exclusively backward-facing calculations outlined in the CUSC for projects that are 5 years or later from your offer acceptance date, as it was felt that where connection dates occur within 5 years of offer acceptance, forward-looking calculations remained relevant for that scenario. But what this means is that going forward, we will look at the gap between your offer acceptance date and your target connection date. So if you have accepted an offer and your connection date is within 5 years of the offer acceptance date, milestones will continue to be calculated on a forward-looking basis, meaning deadlines will mostly be set with your offer acceptance date as the reference point. If, on the other hand, your connection date is more than 5 years out, we'll now anchor the timeline to the connection date or target connection date, and we'll work backwards from there, which those of you with projects at transmission level should be familiar with. And this will effectively mirror that process in line with the CUSC for projects greater than 5 years in duration. So please do refer to the E&A guidance on this, refer to section 16 of the CUSC, or better yet, of course, your connection offers, which will set out the timeframes expected in a backward-facing scenario. One thing I do want to sort of specifically note here, though, is that, because you won't find this in the CUSC, milestone 4 is always measured from offer acceptance on a forward-looking basis, regardless of whatever else is forward or backward-looking. So completion of milestone 4 will be 24 months from offer acceptance for TEA gated and 12 months from offer acceptance for TEA non-gated in all scenarios. Otherwise, for the backward-facing calculation, you'll have a total of 51 months, or otherwise stated as 4.25 years, from your target date to complete all remaining milestones. And that's designed to be far more proportionate and avoid sort of unnecessary modification variations, because it doesn't make sense to complete the earlier milestones. Now, one of the other key changes in this updated guidance is the replacement of the current tolerance process with a remedy notice period, as Jamie mentioned, aligned with that used at the transmission level. So in place of the current process, which feedback tells us that applicants find confusing to have such different mechanisms for distribution and transmission, if a milestone date passes without acceptable evidence, we will now trigger a remedy notice period of 60 calendar days. That means you'll have 60 calendar days following the missed deadline to submit evidence that meets the requirement. And I'll emphasize this again, that 60 calendar days, not working days. And I would also emphasize it's not cumulative like the tolerance process. So each milestone, each of the 8 milestones will have an available parachute of 60 calendar days. You cannot bank remedy days from having not used them in previous milestones, and nor will having required use of remedy days, I should say, in previous milestones reduce how many you have if required for future milestones. 60 calendar days is the straight edge for each milestone. So during that window, your project status will change from on track to eligible for termination, which I think is a slight misnomer, to be honest with you, as while it's designed to reflect that urgent action is required, and that much is true, you have the full 60 calendar days to resolve it for each milestone before actual termination becomes a likely outcome or option. Now, I mentioned earlier that the principles of fairness and proportionality remain core to how we will make assessments going forward. For that reason, you can continue to expect that treatment of later milestones will differ slightly to earlier milestones, which is to say that if one of the earlier milestones is not met, meaning initiating planning, securing planning, land rights, NISO interface and agreed construction plan, and the issue isn't resolved within the remedy period, and it's not due to something clearly outside of your reasonable control, we are likely to proceed to termination in order to keep the queue fair. If one of the later milestones, again, meaning your contestable design, your project commitment and your project construction, which you may hear sometimes reductively called the post-construction milestones. But if one of those is missed, we will assess the circumstances before deciding on termination. And that's a reflection of the fact we recognise that typically by this stage, you're committed financially and operationally. So any termination decisions will be made on a proportionate basis. And we encourage you, please, to engage positively with us so that outcome doesn't happen if it's not needed. So again, I can't stress this enough. Engage with us if you are unsure or unsure what good evidence looks like even for any of your milestones. It saves you rework, it saves us admin, it saves both of us delayed projects, and I hope that it saves avoidable termination decisions. And that also leads me to a reminder on issues outside of your control, as we've referenced a couple of times here. It will remain to be the case that where delays occur due to issues that are beyond your reasonable control, such as planning authority delays, formal planning appeals, force majeure, or delays attributable to the inaction of NISO or ourselves, we will take a proportionate view. For example, one of the questions that we commonly received following the ENA webinar was, what if I don't get through the gated process within 24 months because my DNO didn't submit my evidence to NISO quickly enough? The answer to that is that DNOs are obliged to submit evidence in the first available window after you provide all the evidence to the required standard. Therefore, if a DNO fails to do so and you do not receive a successful outcome within that 24-month window as a result, that would reasonably be considered a reason outside of your control, and we would expect a proportionate approach in that case. But my advice to you all in any such examples of this, of demonstrable delays, is engage early and bring evidence. Again, I'll repeat, we can vary dates where it's justified. We don't want to kick projects out the queue. So as I mentioned, I'll go through, or at very least try to go through each milestone in plain English and not legalese where I can help it. But I want to repeat what I mentioned before. You should find broad familiarity in what follows. There are no new milestones. The same milestones 1 to 8 you're used to remain in place. What has changed is some points of clarity around evidence required and timescales. So I'm going to start non-sequential here with milestone 4, simply because where a NISO interface is required, it's likely to be the starting point for many projects. But to be clear, that's not to say you can't complete other milestones earlier, just that it's a likely starting point for many projects where NISO interface is required. So what is, just as a reminder, milestone 4 is where a transmission evaluation application or transmission impact assessment is submitted to NISO, captured here again under the umbrella term of transmission entry assessment. And you agree in writing to a successful outcome from the NISO process. What's different is that in line with the gated offer process introduced through TM04+, you will now have a defined timeline of 24 months from offer acceptance where the TEA gated process applies, or 12 months where TEA is required, but not the gated process. So that means the gate 2 outcome accepted in writing within the validity period for the gated journey, or written acceptance of NISO's outcomes or conditions in the non-gated journey, which is effectively the MODAP process many of you will be familiar with. So particularly for the gated process, please make sure you submit your Gate 2 readiness packs in a timely manner. I appreciate that a defined 24 months is new, but it was defined specifically to ensure that if you miss the first available window after your offer acceptance, you will have at least one other window for entry, and usually more in all scenarios. So take your time, get it right. Milestone 1, or your responsibility to initiate statutory planning consents. Now, the guidance for milestone 1 has been streamlined, but to be honest, the practical effect is broadly similar. If you have no pre-planning requirements, then evidence of having initiated milestone 1 is expected within 2 months of your offer acceptance, or where NISO interface applies, 2 months from the successful completion of milestone 4. However, if you do have pre-planning requirements and can demonstrate this, an extension is still available, as is the case currently. That extension will usually be 12 months from offer acceptance, but we are open to engagement where longer is required. And I do know that some of our customers have been concerned about those timescales in the absence of a cumulative tolerance period. So please do engage if you have pre-planning requirements that mean you won't be able to hit those deadlines. We do understand that pre-planning requirements will vary. So engage with us, evidence your pre-planning requirements, and we can agree a fair and workable date with you. So milestone 2, or securing your planning decision notice, what has changed is that to give greater clarity to this milestone, whereas it was previously based on your offer acceptance date with all associated caveats around pre-planning, your environmental impact assessments and so on, it will now be triggered in all occasions by completion of milestone 1. So whether you had 2 months, 12 months or longer to complete milestone 1 is no longer important. Upon completion of milestone 1, you will have 12 months to complete milestone 2. That keeps things easy to monitor for all. And what we want to see here is we want to see the planning decision notice reference number visible on the local planning authority portal. Or you can provide the decision letter. But within 12 months of completion of milestone 1, we're looking for evidence that you have secured that statutory planning consent. Milestone 3, land rights, or more specifically, the requirement to secure land rights needed to construct the project. So the evidence requirement is effectively unchanged here, but the good news with this, as I mentioned before, is that where you're going through the gated process, milestone 3 will be considered achieved by receiving a successful outcome to that process. So there's no need to demonstrate this to us separately. Again, for the TEA non-gated journey, the deadline will be 2 months following successful completion of milestone 4. And for no TEA required, it will be 2 months from your offer acceptance, which is aligned, to be honest, with the existing evidence requirements. And again, I suppose it's just another example of this. It's not a whole-scale reimagining of the requirements. Milestone 5 is in relation to the parts of the connection infrastructure that can be designed and constructed either by us or by an independent connection provider or IDNO. For those of you who were present at the ENA webinar in May, this is actually an area that was softened following the feedback we received in the aftermath of that. As it had been proposed prior to that, that this would be a binary requirement for completed design within 6 months of completion of milestone 2. Instead, what was agreed was that, well, obviously our clear preference remains to have designs that are as completed as possible. Partial or phased design submissions, such as first submitted design, may still be accepted. But where this is the case, binding dates for submission of an approved design must be agreed as part of milestone 6 when agreeing the construction plan. So while I'm talking through milestone 5 and milestone 6 sequentially here, it is understood that milestone 5 may often be fulfilled after milestone 6. For transparency, what we're really trying to get away from here is situations where some developers deliberately provide designs that are clearly not fit for purpose because the wording of the milestone makes it possible to consider the milestone met just because something has been submitted. However, we also do understand that 6 months from completion of milestone 2 may not be enough to submit a completed design. And that was clear in the feedback. So again, Engagement and transparency are key here. In all honesty, I know from speaking with our project designers and engineers that they would rather have that discussion than receive something that's kind of just thrown in for the sake of it, so to speak. We'd rather have a partial design and have that conversation about when the full design will be submitted than designs that aren't worth the paper, to be honest, to tick a box. That's really what this was designed to achieve. So milestone 6, and we're getting there, so thanks for coming this far with us. Agreement of your construction plan demonstrating how you will be ready for the connection date. This is currently 6 months from planning permission being secured, and that remains the same in the updated guidance. The only change worth noting here in actual fact is that the ENA guidance document now offers greater clarity over what items should be included within the submitted construction plan. So please do refer again to the ENA guidance document, but that's to say, please ensure that your construction plan includes plant order placement dates, ICP appointment where applicable, design submission dates, including protection and control schemes, construction commencement and completion dates, including critical path construction items, commissioning dates, G99 compliance statement submission, details of any phased increases of capacity required where applicable, or any other relevant milestones that are specific to your project. And then milestone 7, or the project commitment milestone, and this is designed to demonstrate that the project has the necessary contractual and financial commitment for it to proceed, regardless of the delivery model, whether that be us completing the full works, ICP build with us adopting, or IDNO build. The key change to note here, as Jamie alluded to, is greater clarity in respect of what will be considered as having made staged payments, which going forward will mean where we are completing the contestable works, having paid at least 50% of the total contract value. So providing a straight edge to indicate that just having made a staged payment, any staged payment of sort, will not in itself be considered sufficient, and that in order to demonstrate sufficient project commitment, those payments must equal at least 50% of the end-to-end total. Where we're not completing the contestable works, we require a binding contract for installation of the main plant and evidence of sufficient financial commitment to complete the contestable works. As a reminder again of treatment of earlier milestones versus later milestones, and reflective of the fact that your project is likely to be way down the line by the time you reach milestone 7, the deadline for this milestone in terms of timescales, it's not a hard deadline. Unlike some of the earlier milestones, it's not a hard deadline at the outset and will instead be agreed between you and us at the point that the construction plan is agreed. That's to say, the completion of milestone 6. And then finally, commencement and completion of construction works. And as a good place to finish on, in truth, this milestone is unchanged from the existing milestone requirements. The only point I wish to highlight here is that as the construction works milestone incorporates both the commencement of substantive works and the completion of all customer works, it will be measured as both, and it may therefore be subject to agreed interim steps to ensure that projects are continuing to progress sufficiently towards the planned completion date. And hopefully that's clear. And breathe. You know, I started this session with an apology for the technical glitch, which is really to say user error, as it always is or usually is. And I feel I probably must end it with an apology as well, that you've had to hear quite so much of my voice in this last 50 minutes or so, which I wouldn't wish on anyone, to be honest. We're not trying to drive you away, but if you really have a masochistic streak that makes you want to hear more from myself and the team, then again, please feel free to contact us at stakeholderengagement@spenergynetworks.co.uk. That's really a means of saying that if you have any questions or concerns about how the updated guidance will be applied, please do reach out. We do understand that any update of this nature brings commercial uncertainty. We also understand that there will be winners and losers to the application of this process. So if you do have questions or concerns, please do get in touch. We're very happy to help. Also very happy to hear feedback on this webinar that lets us learn going forward. Are we providing you with the information that meets you where you are and gives you in the sort of style and level of detail that you need it? But if I may, I want to finish again on the potential benefits. Greater clarity and less rework. Greater consistency of application by DNOs and across the distribution transmission boundary. And greater progression opportunities, I hope, for serious projects that adhere to the obligations of the contract. So with that, I'd like to offer my warm thanks again for joining and for the work that you all do to bring projects forward. And just to say that on behalf of SP Energy Networks, thank you, and please enjoy the rest of your day. Take care.